Good afternoon and evening, everyone. We are very excited for today's Behind the Idea webinar to learn about copyright. Thank you all for joining us. Before we get started, I did want to thank our webinar sponsor, Corning. It is because of our sponsors and our donors that we're able to bring you programming like this. So thank you so much, Corning, for supporting this webinar. I don't want to take too much time for myself. Let's get to the good stuff. I will pass it off to our speakers, Amy and Jalen, to get us started. Go ahead. I think, Amy, you're going to get us started. Thank you.
Thank you, Kristen. Hi, as Kristen said, I'm Amy Lang, and I'm an intellectual property attorney at Corning Incorporated. I have been here at Corning for about 2 years now. Before that, I worked at a couple of firms in the DC area. And just a brief background here at Corning, I work within our patent department doing both patent prosecution and copyrights. For the patent prosecution part, I work with our Corning inventors to prepare new patent applications, and I communicate back and forth with the United States Patent and Trademark Office to get a patent from those applications. So for the copyright part, though, I also work with our Corning inventors, but in a different way. So when our inventors want to publish an article in a journal, I will review the rights we are conveying to the publisher regarding that article. I also draft agreements granting rights to third parties when they want to use our Corning-owned content, like our Corning images. And as another example, I also review Corning publications, such as our Corning branding or marketing videos, to ensure that we are not improperly using any third-party materials. So that's just a little bit about my background, but what about yours, Jalen?
Thanks, Amy, and good evening, everyone. I am Jalen Johnson. I want to thank Kristen and the IPOEF team for having us both here this evening to talk about copyright. Just so you know a little bit about me, I'm an attorney at the Copyright Office in Washington, D.C., and I work in our Public Information and Education section. It's also known as IPOEF. So the Copyright Office is a primary agency charged with administering the U.S. copyright law and providing impartial and expert advice on copyright law and policy. A little bit about my office in IPOEF. What we do is we administer many of the office's outreach and informational and educational efforts, and we create and maintain the office's publications, the website content, the social media content, electronic news announcements and blogs are all things, products that we maintain in IPOEF, and we produce and facilitate both internal and external events and educational programs. And we serve the public by answering questions. So if you have a question, you can call us, you can email us, you can send us a regular mail, and we'll be able to help you out with your questions related to copyright. As an attorney in IPOEF, I provide legal and technical support to all of these functions. And I'm really happy to be speaking to you all today about some of the copyright basics and hopefully giving you information that will help you to understand copyright, what it is, what it protects, what it doesn't protect, what rights we have as copyright owners, and how we as users of copyrighted content, how we can use that material responsibly. And I know we'll have some time for questions at the end, so please be sure to enter your questions so that we can, Amy and I can answer those questions. So with that, I will get started. Let me make sure I'm sharing my screen. Okay, so you all should be seeing a PowerPoint slide. It says, what is copyright? So that is where we'll start today. We'll start off talking a little bit about some of the basics. What is copyright? What does it protect? And a little bit of the foundational information. So what is copyright? Copyright is a form of intellectual property that protects original works of authorship that are fixed in a tangible medium of expression. So after that sentence, you might still be thinking, okay, well, what is copyright? So what we'll do is we'll go through what each of these terms means so that we can get a better idea of what copyright is, what it protects, and what it doesn't protect. So we'll look at what is a work, what's a work of authorship, what does it mean to be original, and what does it mean to be fixed? All of these things come together to give us the definition of what copyright is and what copyright protects. So first we'll look at what it means to be a work of authorship. Section 102A of the copyright law gives us a really a relatively actually short list of works that constitute copyrightable subject matter. And even though this list is short, it's actually very broad and very extensive. The words that you see in bold are the words that are from the list that is actually listed in the copyright law. And below those, you'll see many of the words that you'll see below are items that I've listed sort of as representative samples of things that we encounter in our everyday lives that we would consider to be copyrightable works. So for example, for literary works, we might read blogs and see social media posts. We might see news articles. We read a lot of text on websites and in other formats. Those are literary works. Musical works would be the music that we listen to, whether we're listening to it. If any of us are musicians, we might be able to read sheet music, so that's copyrightable. That's a copyrightable work. Dramatic works would be plays and musicals, typically those types of works that we would go to a theater to see and see it on the stage, if you will. Pantomimes and choreographic works are certain dance routines and certain routines that are put together with our bodies and our movement. Then we have pictorial, graphic, and sculptural works. So almost anything that you can imagine that's sort of a visual piece of art, if you will. So we've got photographs, website graphics, drawings, paintings. The list goes on and on and on. Motion pictures and audio visual works, basically videos. A lot of us go see movies. We also watch videos on YouTube. We see TikTok. We see Instagram stories. All of those are motion pictures and audio visual works. Then we have sound recordings, which are the actual recorded performance of a particular work. So think about the songs that we stream. If you listen to podcasts, the actual recording of those people talking is a sound recording. Some of us may listen to audiobooks as opposed to reading books in a printed format. All of these are sound recordings. And then there are architectural works, which are basically buildings that we inhabit. So the big takeaway here is that there are categories of works. Categories are very broad and they encompass many different types of works and content that we see daily. So while copyright protects a wide and vast majority of works, and they span many categories, there are some works and some material that inherently fall outside of copyright protection. And this list that you see on the screen now is from section 102B of the law, and it tells us these items are not protected by copyright: ideas, processes, procedures, systems, methods of operation, concepts, principles, discoveries. This material is not protected by copyright. It's very clearly stated in the law. And some people might be surprised to know, well, my idea is not protected by copyright. You know, I want to protect my idea. I want to copyright my idea, but it's not copyright that actually can protect this. I like to describe this as material that sort of undergirds and builds up the copyrightable work that you might have. So copyright would protect the work that either describes your idea or explains it or illustrates it, but it wouldn't protect the idea itself. So for example, you might have an idea or a concept for a YouTube series. The copyright wouldn't protect the idea for that YouTube series, but once you actually make those videos, let's say you write a script, or let's say you produce some original music, the copyright would protect that video, that script, and that music you created, all explaining and illustrating your idea, but the idea itself would still be up for somebody else to perhaps make another YouTube series or even a book or some other work from it. Next slide. So now that we see what a work is, I want to talk about what it means to be original. If you remember earlier, I said that we have to have an original work of authorship. So we know what a work is now. Now let's think about what is originality. What does that mean? So it basically consists of two elements: independent creation and creativity. Independent creation really just means that the work has to be independently created by the author. Or in other words, it can't be copied from another work. So in theory, you could have two people that come up with the same or similar work, and both would be subject to copyright protection as long as the similarities are simply by chance and one did not copy from the other. So that's independent creation. The next requirement is creativity. And for creativity, we just have to have a sufficient amount, sufficient creativity requires that the work contain at least a small amount of creative expression, but it has to be more than trivial. So to satisfy this requirement, a work doesn't have to be particularly innovative or presented in a surprising way, but it does have to be more than entirely mechanical or routine or typical or expected or inevitable is a term that we often use. And when we're thinking about whether it meets those requirements, we're not looking at any subjective considerations. So we're not thinking about, is this a valuable work? Do I like this work? Is it pretty? Is it ugly? Those aren't things that we think about. We only think about the actual objective view or sound of the work. We only consider the actual appearance when we're thinking about whether something is actually sufficiently creative. A lot of works are sufficiently creative, but there are some that really just don't meet that requirement. We want to leave those as building blocks for others to produce and create work. So some examples of those would be words and names and short phrases like titles and slogans. Those wouldn't be original or sufficiently creative for copyright protection. Also, familiar signs and symbols like a heart or a circle or a square. Again, not protected by copyright, not original, not sufficiently creative. And then also things like coloring or colors, red, blue, orange, etc. Those would not be sufficiently creative or original to be protected by copyright. So now that we understand that requirement, I want to focus in on our third requirement, which is fixation. A work has to be fixed in a tangible medium of expression. So what exactly does that mean? It just means that it has to be written down or recorded or otherwise captured in some way so that it's sufficiently permanent or stable enough so that we can perceive it or reproduce it or communicate it to someone else. The majority of works that we encounter are inherently going to be fixed and meet that requirement just by the nature of how they're created. So for example, if you think about an article that you write in a word processing document, as soon as you write that article, it's fixed, it's created, it's there, and it's stable enough so that you can either copy it or email it to someone or do something else with it. So most of the things that we encounter are going to easily meet that requirement. And another very important note on fixation is that fixation is where copyright protection begins. Copyright protection is automatic and it begins the moment the work is written down, recorded, or otherwise captured. You may have heard of registration, and that is important. It provides certain important benefits, but it's not what gives you copyright. We'll talk more about registration at the end of the session today. So once you have a copyrighted work, it's important to know how long that protection lasts. And so as you can see, it lasts a pretty long time, but it doesn't last forever. Copyright protection lasts for the life of the author, so the entire life of the person who created the work, plus 70 years after. That's for most works, but there are works that are called anonymous works or pseudonymous works and works made for hire. Those last for 95 years from the first publication or 120 years from its creation, whichever is shorter between those periods. So we've got all this information about the copyright and about the work and how long it lasts, but who owns the copyright? Ownership begins initially with the author or the person who created the work. Usually the author is the person who created the work. So that's the person who drew it, who typed it, who wrote it down, or who otherwise created that work. They're the initial author, so therefore they are the initial owner. But there is an exception. In certain situations, the person who created the work may not actually be the author of the work. The copyright law has a provision for what's known as works made for hire. And a work made for hire is a work that's either created by an employee within the scope of their employment, so an employee sort of doing their job duties, or it's created under a special commission that has to meet specific requirements of the copyright law, including being a part of a certain category of works and also having to be written in a certain type of agreement and having these particular requirements. So in the case of a work made for hire, the author of the work is actually not the person who created the work, but the author is either the employer of that person or the person who hired that particular party. So in that case, the author would not be the creator. So the author excuse me, so the creator would not be the author and the creator would not be the owner, but the author, ownership still goes back to, ownership still goes back to authorship. But in this case, the author would be a hiring party or the employer. So it can get a little tricky, but there's lots of information about works made for hire on our website. But the important thing to know is that in that case, it's not the creator, but the person who hired that party. Another path to ownership is through transfers. Copyright can be transferred from person to person, business to business. So even if you didn't necessarily create a work or hire to someone to create a work, you can still own a work if someone transfers the ownership to you. When thinking about transfers, there is one thing to keep in mind that's very important, and that's the distinction between owning the actual copyright in the work versus owning the physical item that you have obtained. So an owner of a work still maintains the copyright in it, even if they've sold or given away copies of that work or allow others to do particular things with it or use it. So the person who possesses the physical copy, the physical item, doesn't have all of the rights that the copyright owner has and can usually only do limited things with that particular copy that they have. So one other thing I wanted to ask people, and I clicked off of this slide too soon, but one thing I want you to think about is, are you an owner? Are you a copyright owner? And the answer, I hope you're all nodding your heads and saying, yes, I am a copyright owner, because you are. You know, if you think about those requirements that I just mentioned, having to have a certain type of work, usually if you're, let's say, taking a selfie, you've created a photograph, you fixed it when you click that shutter, you have creativity in the photograph that you created based on however you decided to pose or whether you decided to take it. So you've met all those requirements. As soon as you take that photo and it's fixed, then you have a copyright in your photo. The same would be for, let's say, if any of us are students and we may write a paper or we may write a blog. So when you're doing these things, I want you to remember as you go about your day, you're often creating copyrightable works that you, as a copyright creator, that you own. So that's something that's really important for us to keep in mind as we continue in our conversation today. So as an owner, well, what rights do you have? That's important to know. So copyright is actually more than just one right. A lot of times people think of the literal words copy and right and think that it's just the right to prevent others from copying, when in fact it's a bundle of 6 exclusive rights. So copying is just one of those. And here you'll see a list of those rights that the law tells us that a copyright owner has. So they have the right to do or to authorize others to make reproductions, basically meaning making copies, what we just talked about, preparing derivative works. So those would be things like remixes, revisions, and adaptations. Also to distribute the work, that's an exclusive right of the copyright owner, and to perform or display the work publicly, depending on what type of work it is. And then there's a special public performance right for sound recordings, that's through digital audio transmissions. So one thing I want to do is pause here and think about what I said at the beginning of that last slide about the fact that the owner can engage in these activities, or they can authorize others to engage in these activities. So what does that mean for us? Well, basically it means that if you're a copyright owner, to a large extent, you have the right to control how your work is distributed, adapted, copied, publicly performed, and publicly displayed. But that right is not absolute and unlimited. You have to keep in mind that the rights of the copyright owner are subject to exceptions and limitations. Another thing that we want to think about is the fact that if you want to use a copyright protected work, well, what does this language to do and authorize mean for us as users? Basically, it means that our use needs to be authorized, or if it's not authorized, it must be lawful. So you might be thinking, okay, wait, how can it be lawful or how can it be legal for me to use someone else's work without their permission? And it goes back to what I said initially about the exclusive rights being subject to exceptions and limitations that are set up in the copyright law. And these exceptions and limitations allow for certain uses without the copyright owner's permission if you meet the requirements of the particular exception and limitation. We're going to get more into this, but before we do, I want to look a little bit more at some examples, or actually one example of authorized uses. So a use is authorized basically if you have permission from the copyright owner to use the work in a particular way. That would be authorized. You may have also heard of this referred to as getting a license to use the work, or licensing. So when we use that term, that's usually what we're talking about, is getting permission from the copyright owner to use a particular work. We can receive permission or a license directly from the owner or their representative for a particular type of use, or we can receive permission sort of indirectly. For example, by relying on a license that you didn't necessarily go to the copyright owner to ask for, but it would apply because of other reasons. One example of this is website terms and conditions. So you may have heard this before, but basically terms and conditions are everywhere. Every website where you might post or share content or consume content has terms and conditions that you agree to by using that website. And these documents basically govern our use of the site and explain what we can do and what we can't do. By using this website, we all agree to be bound by these specific rules or terms and conditions. So for copyright owners, generally, there are usually going to be provisions that we agree to that relate to how we allow others to use our original content that we post or upload. And that includes others who might access the site or use a site, and usually the company that owns that particular site. We also are usually giving a license for permissions for certain uses of our work. So that's one of the ways when we're talking about indirect, the user didn't come to you directly to ask, but by using this website and agreeing to their terms and conditions, you've given a certain license for certain types of uses. But that also has implications for the user. And so for the user, there are also parts of the terms and conditions that we need to pay attention to, because they explain what we're allowed to do with the content of others and what we're not allowed to do with the content of others. So a lot of times we see that we're able to repost or share or embed or sometimes add music that's provided or enabled by a website or a network. All of this activity is usually allowed and sort of governed by the conditions of the website. And we agree as users to be in compliance with those particular conditions. So you'll see terms and conditions all over the place. So not only on social media platforms, but also on messaging boards where we might chat with others, publications where we might post a comment or provide some type of feedback. All of that content that we're producing and creating is going to be governed by these website terms and conditions. So it's really important to know that stuff is there. A lot of us don't go and read it, but it's there. It governs our use, and it tells us a lot about what we're allowed to do and not do with the content that we are engaging in on our different platforms. So that was an example of authorized uses. And earlier I talked about, well, you may be able to use work if it's lawful, meaning if you didn't get permission, it's not authorized, but there's some other way you can use it because the copyright law says there are exceptions and limitations. And so this is where we'll take a look at a few of those. If we want to use a work without the copyright owner's permissions, we have to meet the requirements of a particular exception or limitation. There are many exceptions and limitations that are listed in the copyright law. Those are through sections 107 through 122, anyone who's interested. And most of them give specific provisions about the specific types of work and the specific types of uses. So some examples of those are what's called the first sale doctrine, which tells us how we can use a physical copy of a work that we've received from someone. There are educational settings that provide uses for in-person classes. You may have been in a class and you heard your teacher, let's say, reading a book or showing a movie. A lot of that will be governed by the exceptions and limitations. There are also exceptions that apply for online or virtual educational settings and teaching. And then there are statutory licenses. So basically, a statutory license is where you will be able to use a particular work, but you have to pay a statutory fee and comply with some of the other requirements, like giving a notice in order to be able to use that work. A lot of the music that we stream and listen to online is licensed through these statutory provisions. But there is also a more general exception known as fair use that allows someone to use a copyrighted work without permission if the use is fair. And this one is more general because it can be applied to many types of works and many types of uses. Some common scenarios where we see fair use is in works that either criticize or provide commentary of a work, educational and research uses of works, and also works that we see in news reporting. But in order to determine whether a use is fair, we can't just say, oh, well, this is for educational purposes, or this is for criticism purposes, or I'm saying my use is fair, so it's fair. That doesn't determine whether a use is fair. We actually have to consider and balance the 4 factors that are set out in the statute. And really quickly, I'll go over those 4 factors. They're the purpose and character of the use. So what's the purpose of this particular use? And usually courts are gonna consider whether it's for educational or non-commercial purposes. There's the nature of the copyrighted work, meaning is the work highly creative, or is it something that's more fact-based that can determine or weigh in favor of whether or not a use is fair. There's the amount and substantiality of the use. So how much of the work did you use? Did you use a lot of the work? Did you use a little bit of the work? Did you use the most important part of the work? Depending on what the answer to that question is, it can weigh in favor of fair use or not fair use. And then finally, there's the consideration of the effect on the market value of the work. So how will this use potentially affect what money or what value the copyrighted work would generate? And so as you can see, this is a pretty in-depth analysis that happens with each use every time we want to think about whether or not our use is a fair use. So fair use is very popular. There are a lot of misunderstandings about fair use. There's no one particular type of use that we can say it's guaranteed to be fair. So that's something that you really want to keep in mind if you're wanting to rely on fair use. And another important thing is to remember that ultimately fair use is decided by a court. A court makes the ultimate decision. You might think that a use is fair. You might have gone through the factors and sort of weighed them and thought about them, but the copyright owner may disagree. And so in that case, it would be a court who would decide whether or not the use is fair after balancing all of those factors. So that was a quick rundown of some of the copyright basics. And earlier I mentioned, some of the things that copyright protects and doesn't protect, and there may have been some surprises there, but it's good to know that copyright is different from other areas of intellectual property. And so while copyright may not protect certain things, other areas of intellectual property may protect those things. And so Amy now is going to talk to us a little bit about the differences between the 3 forms of intellectual property.
Thanks, Jalen. Yeah, that was a lot of great information about copyrights. I think everyone has to be an expert now, so that was really great. But as Jalen said, copyrights is just one bucket within the intellectual property umbrella. So there's also patents and trademarks within this umbrella as well. And if you don't mind, thanks. So as shown here, patents, trademarks, and copyrights each have different rights and requirements, but there is some overlap in their scope. So for example, one article can potentially have protection under both trademark and copyright law, or an article can have possibly protection both under patent and copyright law. So what are the differences between these kind of intellectual property rights? So as you can see on this slide here, and as Jalen very, very nicely explained, copyrights protect creative expression. Patents, though, protect inventions that are new and usable in some type of industry. Whereas trademarks can be a word, name, symbol, or even a device that's used to identify the source of the goods or services. So trademarks are really more about brand recognition. And on the next slide, you can see a couple of examples to further show the difference between copyrights and trademarks. So the first symbol on the left is a well-known symbol trademarked by Target. And the second symbol is obviously the Nike trademark. Both of these symbols are good examples of trademarks because they clearly identify the source, meaning the company associated with the mark. However, these symbols most likely do not qualify for copyright protection. As Jalen mentioned earlier, these are basically common or familiar shapes, so they do not qualify for copyright protection because they do not have the required creativity. But the Starbucks symbol all the way to the right most likely does qualify for not only trademark, but also copyright protection. It probably has that required creativity and originality necessary for copyright protection. So now let's discuss some other real life examples. How many of you out there are familiar with the Star Wars movies? I'm sure everyone is. But did you ever consider how many and different intellectual property rights the Star Wars has? So just as an example, they have copyright protection in their movies, including the original motion pictures and the scripts themselves. They may also have copyright protection in the characters with each character. But now with regard to trademarks, I read that the Star Wars franchise has about 500 live trademarks still in use today. And that a while ago, Verizon actually had to pay Lucasfilm, which is now Disney, a licensing for using the Droid trademark with Verizon's Android cellular phone device. So the Star Wars franchise, has this trademark. They have many more trademarks, all associated with their different characters, and obviously for the name Star Wars itself. And Star Wars, I'm sure, also has many patent rights. For example, they could have a design patent for their toys, such as some of their action figures. And keep in mind, the packaging of that toy could also have copyright protection. So these are just some examples, again, trying to highlight how copyrights, patents, and trademarks can all overlap in scope. So let's switch gears again and talk about another real life example. How many of you out there are Taylor Swift fans? Well, you may have heard that she is re-recording her previously recorded songs, and she has already re-recorded some of those songs. So Jalen, let's talk about why Taylor Swift is re-recording her albums and how she is able to under copyright law. I'll start off with some of the background from what I understand. So Taylor Swift's earlier albums belonged to Big Machine record label, which she signed with when she was just starting out. And under her contract, Big Machine owned the original master sound recording for all the songs she produced with them. Keep in mind that the owner of a sound recording can control the reproduction and distribution of that sound recording, including the sale and licensing of the sound recording. So Big Machine then sold these rights to Scooter Braun when his company Ithaca Holdings purchased Big Machine. Scooter Braun then sold the rights to Shamrock Holdings for a reported $300 million back in 2019. And my understanding is that this really did not sit well with Taylor Swift. She had apparently asked for the opportunity to buy back the rights on her songs, but was never given what she felt like was a fair deal. And keep in mind, these songs, these are her babies. She wrote on the bathroom floor with her guitar in hand. So she has a lot of sentimental attachment to them and wants to truly own the full scope of these songs. So Taylor Swift has since switched record labels, and under her new contract, she will now own all the original master sound recordings for all her new songs. And Taylor Swift has already re-recorded some of her songs that she originally recorded back with Big Machine record label. Her contract with the Big Machine record label states that she can re-record her songs starting back in November of 2020. But Jalen, let's talk about how can she do so? How can she actually do this under copyright law?
So the interesting thing here, and this is something that I touched on briefly when I talked about, what are works and what's copyrightable, is that we have to keep in mind that anytime we are listening to a song, let's say on the radio or streaming, we're actually experiencing two, what I'll call copyright moments. We're experiencing two separate copyrighted works simultaneously. So there's a copyright in the underlying song that will be the lyrics and the music. And then there's also a copyright in the recorded performance of the song. So in this case, it sounds like, we have Taylor Swift who entered into an agreement that authorized a particular entity to make a recording of these particular songs. So when she made that recording, a sound recording was created. And that in the sort of music industry is generally what people would refer to as a master. You've probably often heard people refer to owning their masters or having the rights to a master. So the master is that sort of commercially produced and distributed recording that we all listen to and that we're encountering when we're turning on our radios or we're, getting into our streaming services. But also, as you heard me mention earlier, the copyright owner of a particular work has rights in that particular work. So because we have two separate works, we have a song and we have a recording of a song, and we have two separate owners. We have the owner of the song and the owner of the recording. So we have sort of two separate sets of rights. We have the right to distribute and make copies and publicly perform the song, but we also have separate rights to distribute and make copies and certain public performances of that sound recording. So when it comes to a case like this, you have an owner of a song who also recorded, but also gave permission for someone else to be the owner of the particular recording, and for whatever reason, who didn't like the ultimate outcome. But because she still had power in the ownership of her songs, she can still exercise her rights as a copyright owner, of course, pursuant to whatever agreements she's made with her record company. But in general, when we're boiling it down to copyright basics, as a copyright songwriter and owner of a copyright protected song, she still has all those rights to do all those things. So whether that be make a copy, make a derivative by re-recording or making some type of remix, as that copyright owner of that song, she would have those rights to engage in or authorize someone else even to engage in all of those particular rights that we talked about a little bit earlier that a copyright owner has. So I hope that is a bit of a breakdown of how that might work, because basically we ultimately have two separate works. We have Taylor Swift owning and being the copyright author of those songs, and then we had that record company owning those particular sound recordings, but through whatever provisions or agreements she had, she's been able to still exercise her rights as a song author and then make new recordings or exercise other exclusive rights in that particular song. And I'll say one more example of what might help us to understand the difference between a song and a sound recording. I'm not sure how many in the audience might be familiar with the song, I Will Always Love You. This is one of my favorite examples to demonstrate the sort of song and sound recording separation, is that song, many of us might know a famous recording that was done by Whitney Houston, but Whitney Houston was not actually the songwriter. Dolly Parton wrote that song. So Dolly Parton owns a sound recording, owns a copyright in the song that she wrote. And whoever Whitney Houston recorded that song with, the record company there would own that sound recording. So you have the song that Dolly Parton wrote, and then you have one particular sound recording that features Whitney Houston. So I hope that helps us drive home the difference between songs and sound recordings.
Yeah, that was great. And yeah, I think it's hard, or it's easy to forget that there's two rights there. There's different rights, and how Dolly Parton and Whitney Houston own those separate rights. And going back to the Taylor Swift example, because she's at least one of the first artists that I know of that's actually re-recording her previous works of art. And just to kind of give this a broader scope, some of the potential drawbacks with that, maybe a little bit outside of the copyright area, but potential drawbacks could be that she could create a bidding war if a third party wants to license one of Taylor Swift's songs So for example, the third party wants to maybe use one of her songs in a commercial. Well, they could create a bidding war between Shamrock's Holdings that, you know, now owns her original master sound recordings, and then between Taylor and with Taylor Swift and the new recordings, and negotiate between, you know, the third party can negotiate between Shamrock Holdings and Taylor Swift to try to get the lowest price for their song, which then could devalue the price of Taylor's music. Another potential drawback is if listeners will actually want to listen to the new re-recorded songs, or if they have a sentimental attachment to the original recordings and prefer to listen to the original versions. And also I understand it's a lot of time and money to re-record. So will Taylor Swift actually be able to do so with all of her original soundtracks? But I guess only time will tell how successful she will be with these new re-recorded songs.
Yeah, and that's definitely, that's the other thing. It's good to think about copyright for sure, but it's also good to think about, you know, other considerations that may be sort of copyright adjacent, if you will, you know, because copyright doesn't necessarily require that you have a particular intention or, you know, reason for doing whatever it is that you want to do with your works. So sometimes, you know, creators probably want to consider other like business considerations or practical considerations in terms of, you know, exercising their exclusive rights. But for copyright purposes, you absolutely have them, and you sort of can do what you will within the bounds of the law.
So Jalen, let's switch gears again, and let's talk about some copyright concerns regarding social media platforms, because you did touch on this with your slides earlier. And I think that we should explore this more, because these social media platforms are great examples of where copyright law frequently comes into play. And how many of you guys out there are on TikTok or Instagram? I'm sure most of you are, or I believe at least a lot of people today are, because these are both examples, you know, TikTok, Instagram, of social media platforms where participants can both post their own content and view content posted by others. So how does this play into copyright though? So Jalen talked about this earlier with taking a selfie. You know, how many of you ever taken a selfie or a picture on your phone and posted that photo to Instagram? So if it's a picture that you took yourself, you should be the original creator of that picture. So there are most likely no copyright issues when you post that picture to your own Instagram account, for example. But what if you're posting someone else's picture to your Instagram account, or using someone else's music in one of your Instagram videos? There's this Julian Bass TikTok video that's been quite popular, in which he is standing in a room and suddenly he has this lightsaber in his hand. And then he turns into this teal type character when he opens his watch sort of. And then he flips backwards and now he has a Spider-Man costume on. And meanwhile, in the background of the video, a Harry Styles song is playing. And in the caption on TikTok, I think it's kind of funny that Julian Bass asked for enough people to retweet his video for Disney to call him. So Jalen, as you know, Julian Bass could have some copyright issues here by using, for example, the Spider-Man Marvel character content, by using the Harry Styles song. Or you talked about this earlier, his use of that content may fall under fair use. Or he may have received permission from Marvel and from Harry Styles to use their content, in which case, as you talked about earlier, he would be okay using their content from a copyright perspective. Any other considerations, Jalen, we should look out for or consider when using social media platforms like TikTok and Instagram?
Well, I would definitely sort of bring us back to the little bit of the, you know, what I discussed earlier, basically. We always want to sort of just have these responsible thoughts, if you will, as we're using content and posting content. You know, one thing I'll caution people is that we often think that because we can access something, that means we are allowed to use it or that we're authorized, which isn't necessarily the case, you know, because on the internet, it's sort of like you can get your hands on some of anything. But that doesn't mean that it's not necessarily protected by copyright or that it's free to use. So I think the most important thing for us to think about, you know, when we're going throughout our social media internet lives and our day-to-day posting and creating content ourselves is, is this content stuff that I created that's fully original, that came from me, or did I get any of it from somewhere else? Meaning, did I, copy a character because this is a character that I like from my favorite TV show? So I have something to say about it. I'm commenting on it. I'm criticizing it or something like that. Or is this something that I just, post because it's pretty and I haven't said anything, but I don't know where this picture came from, but it's just here free for me to use. So it's just like, we just want to be thinking about these things in our minds. Like if we're thinking that we have sort of a fair use, remember that there are 4 factors and that you have to consider all of those factors. And just because it's on the internet, that doesn't mean it's fair use. Just because you were able to access it, that doesn't mean it's fair use. Just because it may be educational or, or because you might write underneath your post, no infringement intended, or I don't own the rights to this. None of those things actually keep us from being copyright infringers, basically. We have to remember we have to either have an authorized use, meaning that we got permission in some way, or we've got to have a lawful use, meaning that we are within one of those statutory exceptions and limitations. And the one that we talked about, obviously, that broadly applies is fair use. And we want to always remember all of those factors. But I will note that terms and conditions are important. We are allowed to do a lot of what we are allowed to do because of them. But it will be a good idea every now and then, you go and you actually, sort of read that stuff. And if you're unsure, if you're not certain, then you can always just try to use something that's original content that you created, or there are other sort of stock content sites that license material from others that you can just go to and then use it in the way that you like. But we definitely want to consider, our use and whether it's responsible. Is it authorized? And if not, is it a fair use? And then the other thing I'll add is that because we're all copyright owners, as I mentioned earlier, we might just want to consider, well, how would, though this is not a consideration for any of the exceptions or limitations, but it's just something to think about for ourselves. How would I like my work to be used, and and in what way? Even though that even won't necessarily get us out of the deep end sometimes, because what you might think is okay, someone else might not. So I say all that to say we should definitely be responsible in thinking about whether our use is authorized or whether our use fits into an exception or limitation. And if not, maybe reconsider how we're going to use that particular work.
Yeah, for sure. Because it's so easy to just copy and paste something without really thinking about the underlying copyright issues. And also too, with that TikTok, the Julian Bass TikTok video where he used the Harry Styles song. So assuming that it doesn't fall under the terms and conditions and it is actually improper use, keep in mind that Harry Styles may not actually think it worthwhile to sue over such an issue. The monetary value of suing may not be worth it to Harry Styles. And Harry Styles may determine that even though that use is improper under copyright law, it may actually help Harry Styles because it spreads the popularity of the song, maybe brings the song to new listeners that would not otherwise hear it. So even though a use is improper, doesn't always mean that someone, that the true owner would take action to protect their rights. And then actually, so here at Corning, we do actually publish a lot of videos. So we have to be careful about these sort of copyright issues. For example, our Day Made of Glass videos have been quite popular, and we've received about a total of 27 million views on those. And so we do a lot of, videos that we publish. And I recently worked on a cease and desist letter here at Corning, in which a third-party company used content from some of our branding videos on their website. And we sent that company a letter basically saying that they were improperly using our copyrighted material. And we requested that third party take down the content from their website. So in response to our letter, that company did indeed remove the content from their website. And now, Jalen, unless you have any other comments, do you want to go into how to register for copyright?
Yeah, definitely. We want to definitely make sure show you all a quick, and actually I'm going to share my screen one more time. Some information on registration and what that is, and why it's important, why it's something that we might consider. As I mentioned earlier, it's not required to protect your work. Your protection exists from the moment that you fix or create your work in that tangible medium, writing it down, recording it. So why register? Well, registration also provides a lot of good benefits. So if you ever found yourself in a situation where you have a work and you want to enforce your copyright in that work, meaning you either want to, basically if you want to sue somebody, the only way you can do that is if you've registered your work or if you've received a refusal letter from the Copyright Office. Another benefit of registration is that it provides a public record. So people who want to contact you either to use your work or for other reasons related to your work, they can look in the Copyright Office records, look at the registration records, and hopefully find who to contact for that particular work. So that means, like, if you want to license your work, you can make money through licensing. Sometimes if you want people to contact you, get in touch with you, ask you for permission. Remember, we are all copyright owners ourselves. So if we want people to ask us for permission, registration will just help facilitate that by creating the public record. And then also, speaking of court, if you actually get into court, there are certain types of awards and damages that you can only get with what's called a timely registration. And then also registration, basically the certificate provides evidence in court of the facts that are on the certificate. So that will be things like who the author is, who the owner is, the fact that this is actually a copyrightable work, because remember, although most works are copyrightable, all are not. So registration provides some additional benefits. Here you'll see a screen of the Copyright Office's website, and in order to register your work, you come to the Copyright Office's website. This is the official place and only place to register your work. And you have a couple of options for accessing the registration portal. You can either go here and click the drop-down menu, or you can scroll down a little bit and you can click here where it says learn more to register your work. So you click here and you click where it says register your work, the registration portal. And this is where you will go to find all of the information about registration. Basically, what you'll need to do is complete an application, send us a copy of your work, and pay the fee for registration. Those are the three components that you will need. The overwhelming majority of the applications we get and we encourage people to submit are electronically. And so to get to that registration electronic application, you would click here, and I'm gonna be like a TV program where it's like you click here and then you'll end up here. Basically, you'll have to sign in, and this will give you the page that you'll come to in order to submit your electronic application. And I will say there are options to submit via paper, but they are much more expensive and they take a much longer time to get your final registration decision. And the overwhelming majority of works can be registered using this electronic portal. And so this area is one that I want to bring our attention to, because this is where you'll go to actually click the registration application. The standard rule is that you can register one work with each application, but there are some exceptions where you can register groups of related works with a single application. So here's what I talked about, the standard rule, where you would register one work with one application. That will be the standard application. And then here are some of our other registration options and exceptions to that standard rule for registering groups of works. And I see that we're getting short on our time. And I also see that we have some questions in the chat. So I'll stop here with registration, but just know that there are those benefits, and that U.S. Copyright Office is the place to register your work. And if there are more questions after, feel free to send them and we can definitely answer those questions. But now I want to give us a little bit of time for the questions, the Q&A that we have in the questions box. So, okay, we have, and I'll stop sharing my screen now. Okay, so the first question we have is, are only architectural works created after 1990 protected by? Yes, so for architectural works, there are the architectural works that are created after 1990 that would be protected by copyright. And for more information on that, on our website, we have what are known as circulars, and there's a circular that explains this requirement for architectural works. And then we have another question that asks, something I've always been curious about is a copyright fair use disclaimer in front of many YouTube videos and how valid it is. It can't possibly cover every scenario that each YouTuber does. And you're absolutely right. That disclaimer that people put on their videos, as I mentioned, either I do not own these rights or no copyright infringement intended, etc. That has no bearing in terms of whether a use might be infringing or whether a use might be fair. So although people put that there, it essentially does not affect the determination of whether a work is fair use or whether a use is fair use or whether a work is perhaps infringing. Does a songwriter have to register? So this is the next question. Does a songwriter have to register their songs as a copyright in order to have rights over them? No, you do not have to register your songs in order to have your copyright. Another thing, just circling back on the point that your copyright exists in your work from the moment it's fixed. So if you're a songwriter, let's say you're writing lyrics, as soon as you write those lyrics down, either in your notepad or on your computer or your iPad or wherever, that's when your copyright exists. You get those extra benefits of registration that I just mentioned if you register with the Copyright Office, and we definitely encourage that, but you don't have to register it in order to have the copyright.
And just to add on to that, just singing it out loud without writing it down in any format is not fixed.
Yes, great point. Thank you, Amy, for adding that. So the next question we have is, if I found an image on some of the free stock photo websites and use it to go with your blog expressing views on a particular topic, can I claim fair use? Or how do we know these image databases versus are cleared the copyright? So I think what you may be asking are two questions. One, can you use the images that you get in the stock photo websites? And then two, sort of how can you trust it? Is that what you, well, okay, yes, I think that's the question. Amy,
I think that's the question.
Yeah, do you want to take a stab at answering that one? Because it sounds like that might
Yeah, so the free stock photo website, the first part of the question. So usually there's several websites that have free stock photos that state that all the photos are that you can use them free of use. But one thing to consider is that I have found that you actually need to go into each individual photo to view the terms and conditions for each individual photo, because some have different disclaimers that other photos do not, in order to determine if it's really within the fair use doctrine or not. So just keep that in mind. And then the other part of the topic, or the other part of the question is, can I use a photo on my blog expressing my views on a topic? So yes, to a degree. If you took a photo from another website or photo that wasn't yours that you created originally, depending on how you use that photo, it could fall under fair use or it could not. You'd have to go through the fair use doctrine, as Jalen mentioned earlier. One thing to consider, though, is that fair use is an affirmative defense. So by raising that defense, you are saying that I am copying, but you're saying it's okay because it falls within this defense. So without actually knowing the true example, it's hard to say whether or not it would be fair use. If you are using just a tiny bit of the original image and using it in a new way, it probably does fall under fair use. If you're using the entire image and not really transforming it at all, I don't know, probably not. So anything to add there, Jalen? Or
nope, I think that was a great answer.
All right, everyone, we are at the top of the hour. I am so sorry if we did not get to your question. But as Jalen mentioned, there are a lot of resources on the US copyright website, as well as the IPOEF website. So if you do want to keep digging into this topic, we encourage you to do so. Thank you everyone for attending today. Thank you, Jalen and Amy, for speaking. It was really enlightening. Thank you so much. So we will see you all on the next Behind the Idea webinar, and have a good evening.
Good night.
Thank you. Thank you, Kristen, for having us.
Thanks, Kristen. Thanks,
Thank you.
Amy.